Mr. Fontenot, does Mr. Fontenot have a license?
Yeah, I'm running it right now, Your Honor.
Please. Mr. Fontenot, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine.
Not eligible, Your Honor.
You are not allowed to drive. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what you have to do in this life. If I find that you drive, I can have a contempt hearing, and every time you drive, you will be facing, or you can be facing 180 days. This is an affidavit. You're going to swear to me that you're not going to drive. I don't care that you need to work. I don't care that you need groceries. You don't have a license. You don't have car insurance in your name. Do not drive. Do you understand? How do you support yourself?
Working. I work.
Okay. Do you have the ability to hire a lawyer?
Yes, well,
It's a yes or no.
no, not really. Well, no.
How, and so that's what I'm asking you. How do you support yourself?
I mean, I just started working. I haven't even got paid yet. I just started working. I've been working 3 days.
You will be expected to work, and that is also a condition of your bond. You need to work full time. Do you understand? And I'm bringing you back in 2 weeks, and I want to know that you have a full-time job. We will give you an application for a court-appointed lawyer, but you must work full time. Do you understand?
So,
And I'm telling you now, if I find that you drive, I'm going to go bananas on your bond. Do you understand? Come on. Mr. Fuentes, you were charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
On March 23rd, in Harris County, officer conducted a traffic stop on a motor vehicle with no front license plate and expired registration. The defendant, the driver, admitted to possessing a gram of marijuana and a handgun in the glove compartment. The handgun was found in the holster and around in the chamber. Officers found a gram of marijuana in the glove compartment under the handgun.
Mr. Fuentes, I'm going to find that there's probable cause to go forward with your case. So he is the driver.
Yes, sir.
Do you have a license to drive?
I'm running it right now.
Please. As a condition of your bond, while this case is open, you are not allowed to be in possession of any weapons. If I find that you have a weapon, I will put you in jail. No more PR bonds for you. This is not a revolving door. Do you understand me?
He does. It's up.
Okay. How old are you, sir?
21.
Okay. How do you support yourself?
I'm a mechanic.
We're going to reset your case to give you time to hire a lawyer. I'm going to have you go to Victoria, sign and reset. We will have you take a seat in the jury box. We'll get your bond conditions. Do not pick up any new cases. Do you understand? All right, come on. No weapons.
Yes, sir.
So I have a plan to reset.
Mr. American, you're charged with assault, bodily injury. You're facing a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. If you're in the box, don't talk, please.
On March 22nd, 2026, in Harris County, Texas.
Hey. Way too close.
Officer was dispatched to an assault. Defendant is complainant's neighbor. Complainant was observed to have a swollen right eye, a cut on his nose, and scratches on his back. Officer was provided a video of the assault. Complainant was sitting down, talking to 2 other individuals when defendants walked towards him and started hitting him multiple times. Co-defendant grabbed him and threw him on the ground. Defendant hit him in the jaw multiple times and dragged him to the front of the apartment complex while co-defendant kicked him.
Is that it?
Yes, Your Honor.
Okay. Do you know if alcohol or anything played a factor in this?
It's not clear to me, Your Honor, if there was, alcohol involved in this incident.
Mr. American, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to have any contact with the complaining witness in this case or the co-defendant in this case. If you violate these conditions, I will order your arrest, put you in jail, no more PR bonds for you. If you are not in this country with permission and you go to jail for any amount of time more than what you did last time, it's a very good possibility they put an immigration detainer on you and you will be stuck like Chuck in custody until this case is over, and then you get shipped off to immigration. Do you understand?
I do not understand everything.
If I put you in jail and immigration finds you and you're not in this country with permission, they may put a detainer on you. Do you understand?
Yes.
Don't violate these conditions. Don't endanger my public. I am not going to warn you again. We are going to reset your case to give you time to hire a lawyer. I will have you sign a reset with Victoria. We will have you take a seat while we get your bond conditions. The bond conditions are no contact with the complaining witness, co-defendant, and no possession of any weapons. You can go ahead and sign the reset. If you can file this case.
Yes, Your Honor.
All right, Judge, the next Spanish arraignment is on page 20. Santos, come on up.
Please. Hi, good morning. Mr. Santos, is there anything aggravating about this? Is there any alcohol in the car while he's driving? Any prior DWIs?
No priors, Your Honor, no alcohol in the vehicle, but there was a crash. Defendant crashed into the vehicle and the opposite.
Okay, any prior, you said no priors?
Priors, Your Honor.
Mr. Santos, as a condition of your bond, I'm ordering you not to consume alcohol, illegal drugs, and you will be randomly tested. If I find that you're consuming, I will revoke your bond and put you in jail. Does he have a license to drive?
We do not have a driver's license on file.
You are not allowed to drive, and that is also a condition of your bond. If I find that you do, then likewise, you will go to jail. You will be signing an affidavit with me today promising, Mr. Santos, that you're not going to drive. I don't care what you have to do. If you do not have a Texas driver's license and liability insurance in your name, do not drive. Do you understand? I'm not going to warn you again. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with them. If they tell me they cannot get a hold of you, I will revoke your bond. For now, I'm going to have you come up here, swear to us that you're not going to drive. We will have you sign a reset and then we'll get you out of here. You will get with Veronica for your bond conditions. Don't use alcohol. I don't care what your excuse is. Do you understand? Okay.
Thank you, Your Honor. Can I get a second?
Yes, thanks. Ms. Murphy, you were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. Does she have a license to drive?
It's not eligible, Your Honor.
You are not allowed to drive. I don't care what you have to do in this life. You want to drive, you need a driver's license, you need liability insurance. If you don't have either, then this is a condition of your bond. I'm ordering you now to obtain a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. Do not use. If you do, I will revoke your bond and put you in jail. Do you understand, man? Do you have the ability to hire a lawyer? Can you file paperwork for the interlock, please? So that I'm sending notice to DPS in Austin so that every police officer in the state knows that you're supposed to drive with an interlock. If they catch you driving a car that doesn't have an interlock, they're going to arrest you. You understand? So do not drive. Deputy Etchegorn is going to give you an application. I need to know everything about you, how much money you have coming in, all sources of income, whether you're married, property you own, cars you have, and then I'll take a look to see whether you qualify. Come on. Mr. Ontiveros, you're charged with terroristic threat of a family or household member. You're facing up to a year in jail and a $4,000 fine. There's a protective order that has been issued in this case, and you need to get to know it. If you do something to violate this protective order, the state can and will file a violation of a protective order against you. As a condition of your bond, I'm ordering you not to have any contact with the complaining witness in this case and not to be in possession of any weapons. You understand? If you violate these conditions, likewise, you will go to jail. No more PR bonds. This is not a revolving door. I'm gonna have you sign a reset. We're gonna get you out of here to hire a lawyer. I'm gonna have you take your seat after you sign a reset. We're gonna have bond conditions created for you to sign. Once you sign them, at that point, you'll be free to go. When you come back, please have a lawyer. Come on. I'd like to do probable cause on this one.
Yes, sir.
Mr. Rivera, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You speak English, correct?
Yes, sir.
On March 7th, 2025, complainant stated that she and her ex-boyfriend defendant assaulted her at her apartment located at 555 Sumner Drive in Harris County, Texas. Complainant stated defendant hit her with his open palm on the left side of her face, then punched her in the nose, causing pain. Officers observed defendant's nose to be red and swollen.
Mr. Rivera, I'm going to find that there's probable cause to go forward with your case. He has a prior violation of protective order and terroristic threat. He's also on 2 felony probations now. Any of those the same complaining witness as this one?
I believe they're different complaining witnesses, Your Honor. I'm going to confirm right now.
What did you say?
I believe they're different and it's confirmed. Yes, Your Honor, different complaining witness.
For the VPO as well?
Yes, Your Honor.
Mr. Rivera, I'm going to find that there's probable cause to go forward with your case. There's a protective order that has been issued. You need to get to know it. If you violate this protective order, the state can and probably will file a violation of protective order against you. It would probably behoove you to hire a lawyer as soon as possible. You're on 2 probations now. You've picked up a new case. You understand me? As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to text you if I find that you're using alcohol or dope. If you have any contact with this person, I will revoke your bond and put you in jail. I will deem you a public danger, and I'm going to make your bond high. I'm going to protect my community at all cost. Do you understand me, sir?
Yes, sir.
We are going to reset your case to give you time to hire a lawyer. So you will get with Victoria to sign a reset. You'll get with Veronica for your bond conditions, and then we'll get you out of here. The one thing we ordered you not to do was pick up a new case. Now you stand charged with evading arrest or detention. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you.
On March 24th, 2026, in Harris County, Texas, officers dispatched through suspicious vehicle call. The reporting party stated he observed female subjects driving around the complex, breaking into vehicles. Officer located the vehicle. Officer exited his patrol vehicle and shined a light into defendant's vehicle. The vehicle began to reverse out of the parking spot. Officer gave command to the driver to stop and announced he was the police. Co-defendant was the driver, the defendant was the passenger. Co-defendant sped off to evade out of the complex. While the vehicle was in motion, defendant opened the passenger door and jumped out of the vehicle. Officer gave commands to defendant to stop, but she failed to comply and began to run on foot away from officer's direction. Officer gave chase for approximately 10 feet and defendant was eventually detained.
Etch, I'm gonna need your help. Miss Ward, I'm gonna find that there's probable cause to go forward with your case. You are on your third case in a month. Guess what happens now, Miss Ward? I'm going to revoke your bond and you will be going into custody, ma'am. You mind appointing a lawyer, please? Are there any co-defendants in this case?
There's,
Co-defendants?
one co-defendant here.
Is this in the middle of the night?
Sorry.
What time is this? Is it middle of the night?
It's not clear from the DMs, Your Honor. I'm checking all.
Okay, good.
That was the last arraignment.
Okay. Any,
DHA?
yeah, come on.
Bottom of 13, Con.
Come up. Yeah, it's all right. Come on. Talk to me.
Good morning.
Oh, we got the BVR.
Yes, I don't know if you saw the email though.
No, I have not seen anything.
Control Services email that said the device was too loose. It immediately went up there on Fair Shade with the comments.
If I remember, there was an alcohol detection.
It was just a loose device. So you-
It was a false positive. It's confirmed that the device was loose. It wasn't installed properly, and so they used it.
Okay, there's no alcohol detected? Okay, all right, we'll continue supervision there.
Thank you.
Okay,
Your Honor, coming forward, the
Sorry.
office report the date, but it's 39 hours. Doesn't even specific.
okay. Do you have a lawyer?
I do.
Okay, just take a seat. We'll wait for them to show up. Okay, thank you, ma'am. Good morning, Mr. Nesbitt. Do you have a lawyer today?
I do. He's a different.
Okay, who is it?
His name's Dustin.
Okay, we'll wait for him to get here then. Okay.
Next one is page 21, Thompson. Or, sorry, Thomas.
Morning, Mr. Thomas. Do you have a lawyer today? Okay, how do you support yourself?
I work full time.
Great, what do you do?
I'm a mechanic.
And how much money do you make a month?
I just $30. But I don't mind if I find it.
You have to qualify for court-appointed lawyers, you know what I mean? It's just, if you spend beyond your means, it's on you. But we don't just give out lawyers like it's candy. I don't have an unlimited supply. So, I'm happy to give you more time. Who do you live with?
Okay.
So you don't pay rent?
Yeah.
And do you have any children?
Yeah.
How many is some? Yeah, 4 kids. Are you providing any kind of support for these children?
They live full time.
Okay. Ed, do you mind giving them an application? We'll give you an application. I need to know everything about you, whether you have any other sources of income, wife, marriage, anything. And then we'll take a look to see whether you qualify. Mr. Carey, you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. As a condition of your bond, I'm ordering you not to have any contact with the complaining witness in this case and not to be in possession of any weapons. Do you understand? If you violate these conditions, I will order your arrest. I will put you in jail. No more PR bonds for you. That is not a revolving door. If you pick up another case, if you endanger my city, it's just not going to go well for you. Do you understand me? And I'm not going to warn you again. How old are you, sir? Do you have the ability to hire a lawyer? How do you support yourself? When is the last time you've had a full-time job? Has it been that long? Okay, it's time for you to get a job. a real legitimate 9 to 5 job, that is something that you need to do. I will give you an application for a court-appointed lawyer, but I'm bringing you back in 2 weeks and I want to see what you have done to get a job. If you've done nothing, it's not going to go well between us. You don't get to sit at home and play Xbox all day while everybody else puts the bill for you. No, sir. You need to be productive so that you have this and you stay out of this. Do you understand? 2 weeks. I want to see 30 applications. Come on. Can you follow the conditions, please? Yeah.
Go ahead and sign for your reason. Judge, I have another one that was off docket.
Okay.
I have the case number when you're ready.
Okay, what is it?
26
Uh-huh.
11996. Amber, come on up.
Let me do this and then I'll help you out. Mr. Hammer, you're charged with theft. You're facing up to 6 months in jail and or $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
It's going to represent Dims, Your Honor. On March 24th, 2026, in Harris County, officer was dispatched to a theft and progress call located at a Target. Upon arrival, officer met the loss prevention officer, who advised that the defendant entered the store. The customer proceeded through multiple aisles, selecting various items, merchandise from the sales floor. The prevention officer maintained continuous observation and watched the defendant conceal the selected merchandise on his person in a manner consistent with shoplifting. The plaintiff further stated that the defendant bypassed all points of sale and exited the store without making any attempt to pay for the concealed merchandise. The total value of the stolen merchandise was $203.99.
Okay. Mr. Hammer, I'm going to find that there's probable cause to go forward with the case. As a condition of your bond, you're ordered not to go to any Target whatsoever for any reason. If you violate these conditions, if you pick up a new case, I will put you in jail. No more PR bonds for you. Do you understand me? Do you have the ability to hire a lawyer? Well, how do you support yourself?
I'm not working right now, but.
When is the last time you've had a full-time job, Mr. Hammer?
Like, I just had interview just a couple of days ago.
You need a full-time job. And likewise, you will be back here in 2 weeks to prove to us that you are working and that you are actively looking. And I want to see 30 applications. Do you understand? Yes, do you mind, or Deputy Williams, do you mind giving me the application? We're going to give you an application. I'm going to have you take a seat in the juror box. Do not leave until you sign the bond conditions. You understand? All right, come on. Do they know about?
I don't know, Judge.
Okay, are you ready? Good morning, Ms. McDonough. Just the last name, please. Smith, okay? In jail or on bond? Okay,
I'm under a probable cause that this is I'm on a ferry road.
sure, okay.
The firearm was found in the back of the passenger side. There were other occupants of the vehicle and he's the driver. I'm arguing that he did not have a hair state control.
Well, I don't even know. Let me hear it first and then we'll,
On December 1st, 2025, in Harris County, officer conducted a traffic stop on a vehicle for expired registration. The driver of the vehicle was identified as the defendant. The vehicle had 2 other passengers. While speaking with the defendant, officer detected a strong odor of marijuana emanating from inside the vehicle. A PC search was conducted. Defendant informed officer he is currently on probation for aggravated assault. During the search, officer discovered a firearm located on the rear passenger floorboard underneath the passenger seat within the arm's reach of all 3 occupants.
okay.
I'm arguing he's the driver. He was not in charge of the passenger.
Well, I mean, he could theoretically put his arm, what, did you say it was an AR?
No, Judge, just a firearm. The type was a Glock 17 handgun.
I mean, you could theoretically just kind of put it back and then someone else just kick it under.
Theoretically, but the facts are it was under the passenger side, and I'm looking, that is quite a reach to that create not near this football. There's also somebody sitting in the seat. Because more than likely.
Did anyone else claim ownership of it?
I don't have those stats in front of me.
Yeah, I don't know. I mean, what do you think?
I think without knowing anything else like that, based on the dents alone, it probably causes us to say, move your legs potentially, let it slide like in the back seat.
I mean, yeah, I think unless, I mean, if you show me that someone else claims ownership of it, then that's one thing. But I mean, you could, if you wanted to, just put the gun under there and just kind of, you know? Sorry.
Thank you.
Yes, ma'am. Mr. Porras.
Good morning, Judge.
Hey, good morning. Yeah, of course.
How are you, Judge?
What's up?
Uh,
Who's your guy?
approaching on Marshall, Washington, Judge.
That's right.
So this is one violation, Judge, he's in the box, I'm calling up, or?
You show, do you have anything to show?
The rabbit. I can think of.
Sure.
Washington. Thank you. So, Judge, as you remember, this is one that I approached the restated bond about a week and a half ago, maybe less than a week ago. We reset him, or you reset him at that time to May the 6th, to do a drug test on that day to make sure that he was clear on that day.
Say it again?
You had reinstated his bond, upon my request, and then you
So-
reset him to May 5th to be here. Typically, Your Honor, as you know, you waive appearances, but you wanted him to be here on that day to do drug tests on that day. And you told us
Well, that was for marijuana.
that was just, my understanding is it's a drug test. The drug test is a drug test. You said,
Sure.
when you explained it to him, Judge, you said no weed, no cocaine, no
Mhm.
methamphetamine, nothing.
Right.
Okay, so Your Honor said on that day that we were gonna bring him back specifically on the 6th to get drug tested and on that, so if he came back positive, Your Honor would forfeit his bond. As you can see, that report, Judge, that you have in front of you, if you got the colored version, there's 4 red lines that say positive, Judge. However, on the bottom where it's on notes number 2, the confirmed positive or the carboxyl THC and benzoyl lexanine,
Mhm.
which are the metabolites that can stay in your body for 10 days, 14 days.
But no, 2 to 6 days.
You can do a quick search.
I did.
on
It
Google,
said 2 to 6 days.
Depending on usage.
He's not supposed to have anything in his body.
I'm saying, but what I'm saying, Judge, those are not active ingredients or active compounds at the time when he's doing the drug test, Judge.
He's got
These are-
cocaine in his system, Victor. He's
Your
not
Honor,
supposed to have anything in
I
his
understand
system.
that, but a quick Google search will show you that this specific compound is in your blood, or it comes out in urine. 10 days, 14 days, depending on usage.
Come up, Mr. Washington. Deputy Williams. Yeah, it's a second bond violation, man. You know, we do what we,
Well, it's technically a first, Your Honor, because this is the one where we spoke about this one where on that specific day when he was supposed to go,
Oh,
he also
right,
received it.
okay,
Notice.
get it. He's still testing positive for cocaine though, man. You know,
Your Honor, but on that day, you said on May 5th, or excuse me, May 6th, when we come back, on that day, if you test positive, then I'm taking you. That's what you told us, Judge. And so.
he's still testing positive
But
cocaine.
this is not an active ingredient, Your Honor, is what I'm saying.
I don't know, but I don't agree with you. It's 9 days after the fact. He's still testing positive. You're going to jail. You're not supposed to be using anything. I mean, I can't continue to reinstate. No.
Well, you're not continuing to reinstate, Judge. The first one should have never been forfeited to begin with, or revoked to begin with, because there was that miscommunication, Judge.
Yeah. I'm sorry. It's 9 days after the fact. I'm not going to just continue to, you know, He's got to know that we mean business. You know, sorry, Victor.
Okay,
His bond right now is at 3,000. I'm doing it 5,001.
Can we leave it at 3,000?
It's 3,000 now.
Can we do 3,500? I mean, again, this is the first violation. The first violation, which raised it from whatever it was to the 3,000, should never happen.
I'll do 4,001. All right.
Okay.
All right.
Thank you, Judge.
All right, man. So 4,001 on Washington. Hi, Anna.
Good morning, Judge. You have footage.
Yeah. Tell me something nice.
Give me a minute.
Right. Touche. All right. So what's up?
I'm here on Audrey. It's good.
Okay.
So she's got an EDR. And if you recall, Judge, this is the one that you wanted to talk to her on Thursday. She had a interlock issue. However, in speaking with pretrial, I'm not sure exactly what happened.
Yeah, they gave her another PR bond. That's what happened.
Well,
Okay.
and.
Where's Miss Taylor now?
I'm sorry,
Where's Miss Taylor now?
she's.
It's not. It's not.
So with the interlock violation, I'm not sure exactly what happened. I don't know the trials right at the top of my head. It's all the pre-trial.
Did she even have an interlock in the car?
Yes, she had an interlock.
So this was the bond violation. He blew, fire drive with count 03,
But based on the timing of it, if you look at the time zone, it's like, what, at 6:08, it was 0, and then at 6:15, it was a 0.03, and then she blew again at like 6:58, and it was a 0. So I don't know what happened. But
She's supposed to retest immediately, right?
it was, the roll, testing, so she was, it's like they're like currently driving and they're blowing as they're driving. And so, that one is like.
How would it start and let her drive if she blew a .03?
Well, it's because her first flow was a 6:08. So that allowed her to start the car and it was a 0.00. And then she was driving on the 0:3. And then,
Oh, I see. Okay, so she blows at 6:08. It's a 0. Then she blows a positive .03.
like 7 minutes later. And then it had her blow again and like another 30 minutes
Okay,
is a 0. And just, I don't know what happened, but that the human body doesn't process.
I get it. There must be a false positive or something. I mean, how else could it happen, right?
I mean, even if she had blown a 0.
Because she blows a 0 at 6:53. If it's a rolling, would it really wait from 6:15 to 6:50 to test again? That's weird.
the guy should have, given a prompt to test it in 15 minutes.
Right.
And so, there's no reported flow in those.
Did it prompt it to?
I'm not sure,
Can you look to see if it did?
Well, usually if they miss a blow, it shows up on the report as a miss or a skip.
This is really weird.
Yes.
I can see often some people go to the device company to see if you have any explanation for it.
Yeah.
But just the human body doesn't process
But
it.
regardless, how do we go forward when she's driving on a suspended license anyway?
So, as far as that goes, Judge, I'm gonna help her get an informational.
But she's still driving on a suspended license.
Well, she's not driving now, but she's aware of it. She did.
Because she got arrested again. It's a third arrest. Now, she's on deferred for an aggravated assault, picks up DWI, and now we have,
And Judge, just for the court's awareness, normally when I get appointed on the DWI, I go ahead and do the driver's license.
did you do the LR hearing in this one?
However, in this situation, it was dismissed and refiled because of the paperwork snafu. And so by the time I got.
What paperwork's now?
The officer left something out that, for PC. And I
Okay.
guess before a judge found PC, they dismissed it. And so by the time I got appointed on the case, we were outside the window. And it found.
But she's had enough DWIs that,
Well, she was arrested for one previous one that was dismissed. It looks like she has 3 total DWIs. 3 DWI arrests because one of them was dismissed from rehab. And had I been appointed within the marijuana area, her license would not have been suspended because it was a failure. But what the officer did was to took 2 incomplete blows and put them together to make one test. So had we done the ALR, not.
does that justify?
I don't know that it justifies it. She said that she did not get a letter from DPS about the ALR suspension. It's DPS, so
It's currently suspended now, right?
it is currently suspended.
I could confirm it, running her license training.
But now that she is aware of it, she is not driving. She had someone bring her to court.
So I'm gonna amend the condition, put a scram on her, because I want to make sure she's not drinking. I'm gonna leave the thing on, because I want to make sure she's not driving anymore.
Okay,
I'm at wit's end.
okay.
Like I can't, it's just way too much drama, and I'm ready to like set for trial. It's just
Oh,
way too
and that's
much.
what I would like to do with this.
Well, the suspended license case is just way too early. I mean, it's only
Okay,
not even 3 days old. I can't set that for trial, but
okay. And I
are
can
you
have
ready
it-
on the DWI?
Sorry,
Taylor, are you ready on the DWI to set it?
I haven't had too much of a chance to look at it. I haven't detailed it yet. I would like more.
So I'll give you a week. I'll set for a week. Take a look at everything. Be ready, because it's just way too much drama. And
Okay. And Judge, since she's been previously found indigent, can I file occupation in this court in the way that I am being? They are driving legally?
Yeah.
Okay,
yeah, I'm okay with that. Sure.
maybe excuse.
Yes, ma'am.
Okay.
But is the no tolerance. If they're slightest,
Okay, understood.
okay.
So,
Yeah. Good morning, Mr. LeGrand.
Good morning, Judge. I have Justin Nesbitt. It's an arraignment on your docket.
Hey, do you mind hitting the button on the sound bar? Just give me 1 second, Mr. LeGrand. It's not working. Just one time. All right, say something.
Justin Nesbitt. It's an arraignment.
There we go. Okay. You just want to reset?
Yes, sir. It's a racing on a highway case.
Got it. Hey,
Yes,
Nesbitt, I've got Mr. LeGrand here. It's just a reset.
House, May 19th to the 21st.
Did you hear that? You're muted.
I haven't done this in a while, Judge. The 21st is great.
Wednesday.
21st, yeah. Okay, and it'll be waived for that one, okay?
Okay. Thank you, Judge.
All right, man, have fun.
All right.
Take care.
Bye.
Come on up.
I think that's all of them. Hey, oh, I'm sorry.
No, you're fine.
Just yell next time. Hey, good morning.
I'm here on Mr. Watson.
Okay.
Mr. Watson. Charlie, I guess maybe just like a year.
Shut the front door. He picked up a new case.
Well, actually, Judge, this was filed on March 24th, but it says that the offense was on January 27th. And they just chose to file it, I guess, 2 months later.
Where's Mr. Watson now?
He's here, he's in the box.
Michael King. Michael King.
Do we have PC?
Yeah, sure. Okay.
It's loading, sorry.
Lord have mercy.
They do it for your entertainment.
That's right.
On the step,
Yeah, the newest one. Now number 4. Do you have space back there? You got space?
We have enough space.
on January 7th, 2026, in Harris County, officer review a Pasadena Police Department report of an assignment case for follow-up investigation. Contacted the complaining witness, the store manager of an academy located off of Beltway 8 in Pasadena in Harris County. Complainant stated that on January 27th, the defendant entered the store and that the complainant had received a clock alert on his cell phone indicating a known suspect vehicle attached to prior academy thefts had entered the store parking lot. The complainant later found the defendant was concealing items under his clothing and observed him exiting the business without making any attempt to make payment.
Wow, those flock alerts, huh? Wow.
Complainant reported the defendant fleeing the same vehicle he previously received a clock alert on and advised officer that he observed the defendant walking towards the front of the store with blue and pink articles of clothing hanging out from under his clothes. Additionally, he observed the defendant almost dropping those items, which led to him noticing the concealment. Complainant advised officer that he returned to the area where he noticed particular shirts on display and discovered 3 hangers on the display rack missing the articles of clothing from them. Complainant confirmed those items.
Come up, Mr. Watson.
They were the exact items observed concealed on the defendant when they exited the business.
How much?
So they were 3 shirts valued at $59.50 each. So they don't have the total in the DINs, Your Honor, but they're-
What is the date of this one?
I'm sorry.
So this one is January 27, 2026.
I know, I'll bring that up. I mean, Mr. Watson is just telling me he's been on an ankle monitor since before this charge, so I don't know. I mean, I know that ankle monitor gives you a location.
Well, he's been an ankle monitor now because he's picked up 3 cases and he got it prior to his release. But yet we still have case after case after case.
I don't know if the monitor itself was tracking like a barrier location of that academy. I don't know how part of the on conditions. I know that he had a no return to academy. And at the time that this officer allegedly, or the person, the complainant allegedly saw this happen, Mr. Watson would have already been arrested, and I'm assuming they would have been followed up with about this charge. Actually, oh, this is a charge that even predates the other theft. So he would have been arrested on the new charge.
So I'm not going to revoke the old one. Actually, the weed case, I will leave alone. Actually, the felony's not my case, but the theft case, he was on bond for that case when he picked up this case, when he picked up the weed case. So I'm not going to touch the weed, but I think that the prior theft, he was well on bond for that one. He's been on bond for that one. Actually, no, when did he make bond on that?
Actually, no, I lied. The theft was February of last year. This new charge is alleging January of
This is this year, right?
And I mean, Mr. McLaughlin didn't read this Jim was very weird.
Why?
Very weird. He says that he saw articles of clothing under his shirt. He only describes them as pink and blue articles of clothing. But he says that he can identify all three articles of clothing. He makes no description of what these articles of clothing are.
Well, regardless, it's still over the,
Well, what I'm saying is
Threshold.
that it's interesting to me that he can identify which pieces of clothing they are if they're stuck underneath his shirt.
sure, and that's great, probably for a jury, right? But for purposes of probable cause,
Officer also reviewed surveillance, but I just was,
there's also surveillance of, yeah, Mr. Watson.
Well, he doesn't, I understand, he doesn't describe the surveillance, he just says the surveillance reflects the story. He also apparently, I don't know why they're having to do this roundabout way of identifying him. Apparently he was stopped by another officer and he reviewed that officer's body cam footage and I guess compared it with his booking photo. So I don't know if they compared that to their surveillance or not. I guess they compared it to the surveillance video, but this is a year after he's been in custody on this theft. I don't understand how they do not have information about this person. Also, this isn't for PC, but I know that we can get a list from, unless they delete the GPS information of basically every time Mr. Watson left an area and went to another area, they track it by the exact address. I know it's not gonna alert when he goes to an academy, it's gonna tell us if he ever went to that academy. I don't know how about I.
Regardless, I'm going to find that there's probable cause and I'm not going to give you a PR bond. You will be going to jail today, Mr. Watson, and I don't know what I need to do to just,
Why would I go do something not to go to an academy at all? Why would I do that? That would be the dumbest thing I could ever do. Like, you gave me a bond condition, I already messed up.
just don't. They've already filed it. We'll see the surveillance. I don't know. But- That's nice. Mr. Watson. That's nice.
I apologize. It's just upset because he had no idea
Get it?
that he had this warrant. I mean, I know they don't alert you, but he came in here, deputy didn't tell me he had a warrant. I had to tell the court that we had a warrant.
I didn't know either, but at some point there can, I don't even know, maybe there's more. I don't know.
Did we set a bond, Judge?
I'm going to, I don't know what though. I don't know what. Give me a second. Let me talk to them, get them on, then
Okay.
we'll discuss.
Just quickly, Your Honor, I've got Dacia Turner, she's got a BVR. I need to look at the data and the pretrial officer saying I can't get what she has. It's not in my email. It's not in images. She said if you said I could look at it, then I can be better prepared.
So here's it. I'll set you for a formal bond hearing this coming up Monday.
She's here. We were set for today.
Well, you said you need records.
She has them. I'm ready to go for today if we can get, if I can just look at what the motives are. But
I-
don't
ask
know
Ronnie.
that. You're either gonna shoo her out.
Well, here's what I'm gonna do. I mean, I'm gonna put a device on her ankle now,
Okay,
the scram. And any further violations, that's it.
okay, do you want an explanation? It's not gonna
I
change,
don't
probably
care.
what do a scram or
No.
not, but do you care to hear? I haven't, okay.
I'm giving you another chance now, but if
Thank
it
you.
happens again,
Thank you.
I'm gonna lose my, you know what? So, and then I'll pay for it too.
Thank you.
So, okay. Hi, Brandon.
Good morning. Raymond Judge.
Okay.
Say it in Spanish. They call it up, Judge.
Oh, yeah, please.
Yes, sir.
I thought that was.
Yes.
Does he, oh, he doesn't speak English. Okay. Mr. Ibarra, you were charged with assault. Shh. You were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. Okay.
Okay. On March 23rd, officer in Harris County responded to an assault call. Officer on scene advised that he was flagged down by a witness reporting a male in a truck hitting a female, striking her several times. Witness pointed to the truck, which was leaving the parking lot. An officer conducted a traffic stop on the vehicle. Officers observed a strong odor of alcoholic beverage from the defendant's person and red glossy eyes. Complainant advised that she was in a dating relationship with the defendant and they had a child together, which was in the rear passenger seat of the motor vehicle.
The child or
The child.
okay.
The complainant advised officers that the defendant slapped her across the face and that she felt pain. Officers observed visible red marks on her cheek. Defendant advised that he has 10 Modelo beers. And they did SFSTs as well.
So you have a witness that's able to identify and see and corroborate that it happened.
Yes, Judge, the complaining witness is in the passenger seat.
Yeah.
You ever got felon conditions against the 405?
I'm going to order him not to consume alcohol or legal drugs, but I wasn't going to do any kind of device.
Yes, sir.
Mr. Ibarra, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to have any contact with the complaining witness in this case and not to be in possession of any weapons. There's a protective order that has been issued and you need to get to know it. If you violate the protective order, the state can and probably will file a violation of a protective order against you. That is one of the worst misdemeanor cases you can pick up. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, they will put a detainer on you and you will be stuck in custody for a long time. Do you understand?
Yes.
Don't have contact with this person. I don't care what you need to do. I don't care that you have a child. You cannot justify contact in any manner. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Mr. Strauss. Mr. Strauss, if he tells me he cannot get a hold of you, I will revoke your bond. For now, I'll get you to Victoria, sign a reset. You'll get with Veronica for your bond conditions. And after that, you're free to go.
Your Honor, thank you.
Okay, you're representing him upstairs.
Yes, sir.
Okay, great.
Sorry, I didn't go to the first one. Yes, sir.
Yeah, okay.
Thank you, Judge.
All right, good luck. So just no alcohol, no drugs, random testing. He's got a monitor upstairs, so if they see any BVRs, let us know too. No contact, no weapons with the complaining witness. That's it.
Thank you.
Oh. If he doesn't have a license, no driver. Okay. Joe,
Yes, sir.
hi, bud.
You got a Martin Chop today?
What's the last name? Oh, Chuck.
Chin Chop. PHENCHOC, a Martin Chop.
Where are we headed? with
Okay,
this?
so this is where we're at. He's taking the T-RAS tomorrow, so I'm gonna ask for a walkthrough today. He had a BVR because his phone broke. He's got a new phone. He
The
came on
PTO is denied though, right?
initially, but then on the 17th, Chief Abbey granted it because they couldn't, well, there is no restitution. They did the RIP, there's no restitution, so we're good on that. That day, she okayed PTI, so we scheduled the T-RAS for tomorrow. In between then, And that's why he had a skip test. He has a new phone. He's given that pre-trial. We came on Friday, you weren't here, but he was ordered to take a test, came out negative, so he's okay.
Okay,
Just need-
all right, we'll just continue supervision then.
Okay, can we do the walk with the T-Rex?
Yeah, today. Mhm, yeah, for sure. And then we'll set you like 2 weeks.
Okay.
Okay, bye, Joe. Kobe, you ready?
I think we're good, Judge. I
Good.
thought I had approached, but it looks like they've already been in front of you and gotten bond conditions, my two clients, so.
Easy money.
Thank you.
Mr. Johnson, Antoine, you're muted.
All right. I was just notifying the court I was coming in from Walker County. I was set for trial out there, but didn't want to file a Harris County continuance because I've set that trial 4 times and we never go. Anyway, I'm coming back in town and just wanted to let the court know that I'll probably be like 30, 45 minutes.
Who's your defendant?
Anthony Brandon today.
Was it in jail?
I think it was Brandon, he said. Yeah, Brandon is the last name in jail.
Okay.
Let me see.
But I won't be that long. I'm actually seeing downtown now, so I'm probably, I don't know, 20 minutes out.
Oh, hey, this is a no PC, I think.
It was. It said defendant was discharged, but still wants to make the
It
appearance.
says defendant discharge. What the? Hey, what happened on Brandon? Weird. Unless it's a
Oh,
mis-
it's just, filed, it was under the amount that we filed, that was filed at intake, 189, filed as above 750.
Oh, that's right. What do you guys want to do? I mean, we're holding him, dude. But
I'll file this right now.
okay. And then, yeah, if you're gonna refile it, but at least, I mean, he's made bond on the felony case. Before we were here last time, he had not made bond, right? Okay, hey, they're gonna dismiss it, Antoine,
Perfect. Okay, thank you, Your Honor.
okay?
Okay, thank you. I appreciate it.
Take care, man.
Bye-bye.
What do you think is a reasonable bond for Mr. Watson, considering all the stuff that's happened?
Considering that the price predated, even the PLM charge, you can get it on.
He still picked it up this January. He's been on bond for the last year for
All I'm
theft.
saying is that he paid for the PLM, he paid it on the PLM. It's not like he's trying to skirt the law. He came in here, he was taking.
But he keeps picking stuff up. We're now on number 4 that's open.
I know.
How do we get his attention? Not with, I mean, really, how do we get his attention?
I understand that she's claiming complete innocence for this, so I'm not gonna advocate for anything besides that.
I get it, sure,
Council full reset?
but nevertheless, we're still on number 4.
Understandable.
What do you think?
I would just rather set it the same amount of PO and bond
Yeah.
possession.
I think that's too low,
Okay.
but if that's what you're asking for, then that's what I'm gonna do. I was thinking 25,000, just like the felony, because I wanted him to understand that you just, but he asked for 10, that's what I'm gonna do.
We're setting that time.
10,004,
Work,
yeah,
are we leaving the other bonds?
Yeah. yeah, because, I mean, he made a bond on this theft case February, right? This was before that. The POM was obviously after that. But let me tell you though, Alice, if he picks up a 5th case, I am truly, it's gonna hit, just,
Yeah.
so please advise him accordingly that if he doesn't live like a halo above his head, okay?
Yes, sir.
All right. Obviously, no going back to the first step was at Academy as well. Right. I wonder. Hey, Veronica, is there a way to put some kind of alert where if someone goes to an academy, any academy, that we would be notified? How do we do? Is that possible?
I do know that there is a way to, cover that light, search. I can ask, ESC supervisor exactly how we do it.
I would just want to make sure that dude doesn't go to any academy whatsoever. And if he does, that we're somehow notified. I don't know if they can do that. If so, can we? Please? Okay. So just no alcohol, no drugs, no new cases, and that's it. We'll see what happens. I'll obviously pop up on tomorrow's docket. And so just, we'll see. Okay? All right. Thanks.
Thanks, Judge Maybe.
Yes, ma'am. Hey, good morning. Good morning.
I have Mr. Eduardo Garcia happy today. Mr. Garcia, Mr. Garcia is on probation out of your court, I think for about 18 months. For a DWI, and he picked up a new case for assault on a security guard. In one of the felony courts. And that case is still going on because he really wasn't a security guard, and there's a lot of issues on that case. It wasn't a security guard, he was just a bouncer, and the facts are debatable. So, but that case is still going on. But what I want to do here is, you've already chewed him out and admonished him because he was the one that went to work out of town in Beaumont or wherever he went. Anyway, so he's been doing good. He's scared to death. He wants to stay on probation. I think he's better be left on probation than thrown in the slammer. I mean, probation is good. Probation is rehabilitated and whatnot. He did get in trouble.
But he's got a bond violation.
The bond violation I saw, if I read what the bond violation is, that he's supposedly stopped at a gas station on the way back from Beaumont. I mean,
He's not supposed to.
we're gonna go to the rules and we gotta stop.
Well, then you prepare before you go, you know? Like you can do all the, how am I supposed to know what he's doing? But, you know, when we told him, we said, you go straight to work, straight home. And I admonished him over and over, don't deviate. We're not allowed to go to Burger King. You're not allowed to go to Exxon. You're not allowed to do this. You go straight to work, straight to home. We give you a curfew. And here we are, yet.
A gas station, but it's not like he stopped at a bar, a cantina, and stopped at a gas station. On the way back from work, his job was over that day. He's coming back to Houston. He finished that job.
I know that you don't think it's a big deal,
Not really.
you know,
Station.
but conditions are there for a reason. And I didn't want him to even be out at all.
We had to drive back to Houston. Yes, his job was over.
What I'm trying to tell you is I didn't want him to be out in the middle of the night at all. And I relented because you guys asked, you say, hey, he's got to work, yada, yada, this, that. And I said, okay, but the condition is you go straight to work, straight home. Okay, we're going to do that. And here we are.
He stopped at a gas station. Come on, Judge, you gotta take a piss. I go to the restroom, it's not like from his job site back to Houston, it's not like it's 15 minutes, it's distant.
Then take a piss before you leave. I've told you time and again.
Our bodies don't work that way. When our body tells us we gotta take a piss, we gotta take a piss. I don't just take a piss, you know, every once an hour.
Mr. Reyes,
Right, yes, sir.
how do we know he's taking a piss? How do I know he's not doing something else?
I don't know if he has a breathalyzer in the car or what he has, but I'm sure that breathalyzer
It looks like the last time we came before, we gave him a scram device, but it's been 1 to 5.
I don't know what I'm gonna do with him, Mr. Reyes. I don't know.
Could we do this, Judge? Could we reset it and see how the case in the felony court goes? Because I'm pretty optimistic about that, but I don't know what's gonna happen. I know that. See what happens in the felony.
In the interim, he still gets to violate conditions though.
No, absolutely not. I just asked him if he's been reporting to probation. He's still reporting to probation. I don't know if he has a new job.
Come up.
I don't know if he has a new job.
What part of you are not allowed to stop at any other place did you not understand?
Your Honor, I wasn't driving. I wasn't the one driving. They were coming back, the job was done. So the guy wanted to stop at the restaurant, I told him, and he's like, I had to take it.
Take a seat for me in the jury box. I don't know, Mr. Reyes. Just
Okay.
let me talk to him real quick. Come on. Hey,
Kasha.
what's the last name?
Kasha.
Cash.
Oh, Casher. Okay. What are we doing with Mr. Casher?
You know, this case, I did that it is a decision.
We have a restitution dismissed. It was involved for a while. We had
Sure.
restitution information.
How much is it?
I believe $1,000. There's a bill in the portal that's available for defense. So
Okay, so how long is it gonna take to get,
You know,
or do you want, is that what you want to do?
yes, sir.
Okay, how long is it gonna take you to get the $1,000?
I know it's 7 months.
It's 300 days. I'll give you some time, but I mean, let's do this. I'm gonna set it for trial because I'm not gonna wait in hopes that he gets it done. He either gets it done and we'll give him 3 weeks. Either, you know what, we'll do 30 days, but I'm setting it for trial. If he doesn't have it done, he'll be put to trial. Okay, so exactly 30 days today. That'll be April 28th. So on Casher, if you don't mind setting for jury trial
Yes.
on the 28th. Okay, if he doesn't have it done by then he'll be put to trial. Okay, okay,
Thank you.
thanks. Get ready. Counsel, hey, morning.
I'm pretty sure. See the Kasha.
Okay,
Shouldn't be Paul.
just the last name.
Paul, Hall.
Okay, or do you want to give me the,
I'm not the cause number.
okay, what is it?
Cause number is 261-0662. Judge, we have the bill lawsuit here, that's the PSR when completed.
Okay, come up, Ms. Hall.
And the first DWS from like 8 years ago, she successfully completed probation. This is the DWS second.
Sure.
Okay.
Hello.
Ms. Hall, you're charged with driving while intoxicated. Second offense, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you can afford one, one will be appointed to you. Okay.
On February 12th, 2026, in Harris County, Texas, officer was dispatched to a vehicle crash located on Lacey Road. Officer witness stated that they observed the vehicle crash into a fire hydrant at speed limit and speed limit signs. The witness stated he attempted to check on the driver, was identified as defendant to be, the witness observed the defendant to be in the driver's seat of the vehicle.
Okay.
Witness observed, sorry, Your Honor. Witness stated he observed the defendant attempt to drive away from the scene, but was unsuccessful due to the vehicle being disabled. Officer encountered the defendant and noticed blurred speech, glossy eyes, and the odor of alcoholic beverage from defendant's breath. Defendant performed standard field sobriety test, results were 6 out of 6 HGN. 7 out of 8 walking turn, and 4 out of 4 one-leg stand. Officer found an open container of tequila in the center console of the vehicle. The IC was read and defendant refused to provide a sample of blood or breath. A blood warrant was signed and blood was drawn.
Are you alleging that she's consuming while drinking?
There was an open container in the vehicle, Your Honor, and it was 3/4 full.
Okay,
And Judge, this is a 2B because she was taken to the hospital and in the hospital. Basically, we just let the police take her into custody that night.
how high is the blood? Let's see.
And Your Honor, we do have blood results back. Result from 0.301.
301. Oof. Holy moly. Ma'am, I'm going to find that there's probable cause to go forward with your case. Does she have a license to drive?
I'm running her license right now, Your Honor.
As a condition of your bond, I'm ordering you not to drive any vehicle that's not equipped with an ignition interlock on it. If I catch you driving a vehicle that doesn't have an interlock, I will revoke your bond and put you in jail. No more PR bonds. This is not a revolving door. I don't care who you are. I don't care how old you are. I don't care what color you are. You violate conditions. I only have one place for you. Do you understand? You will also get a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. You do? Do you understand? Don't use alcohol at all. Don't use anything that has alcohol in it. I don't care what the excuse is. Cakes, candies, foods, gums, energy drinks, tequila, lollipops, hair dyes. I've heard it all. It doesn't matter. Do you understand?
Her license is eligible, Your Honor.
Okay, you're also not allowed to drive unless you have valid liability insurance in your name. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with them and they'll tell you if and when you have to come back to court. Do you understand these conditions? Okay, so for now, we'll have you sign a reset. You'll get with Veronica for your bond conditions, and after that, you'll be free to go.
Is it a PR bond this morning? You treat it like a.
Oh,
bail bond?
no, it's a DWS second. So what do you think about bond? What's great state of Texas? Do you have a recommendation?
2,000, Your Honor.
Judge, we would request a PR bond, just due to the age of the last case.
I'll set the bond at 2,000 and then I'll release her to you guys. And then just don't use alcohol. Do you understand? Or illegal drugs? Okay, all right, got it.
Thank you so much.
Okay, thanks, guys, please. Hey, hi, Frank, what's up, man? It's just the last name. Okay.
He is in the jury box for Bob.
Yeah,
An hour late.
well, he left.
2 times. Yes.
When did he come back?
Now. Like I said,
So what should we do?
I asked him if he needed to extend this.
No, I'm debating whether to put him in jail, not give him a reward, Frank. I'm not.
This is his first bond violation.
No, but two different instances where he's just flaunting and just doing whatever the hell he wants to do. Mr. Barrera, come up. Does he speak English? How much do you want to go to jail, Mr. Barrera? You're begging for it. If you ever violate again, it's absolutely no tolerance going forward. You violate again, then it's not going to go well. Do you understand me? Last chance. We'll continue supervision as long as there's no contact with complaining witnesses there.
Correct, no contact.
Okay. Got it. Okay. All right. We'll continue.
Appreciate that.
Last time, Frank.
Yes, sir.
Hi.
Good morning, David.
Good morning. Davis. Yes.
Is David?
Ms. Davis, you're charged with how many cases she had?
Plan to dismissing the resist.
The resisting? Okay. So you're charged with a total of 3 cases. You're charged with resisting arrest, theft, and terroristic threat. you have worked out an agreement where they're offering you 12 days with credit for 10 on the terroristic threat, 3 days with credit for 8 on the theft case. You are giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept these will reflect as convictions on your record. They will be there for the rest of your life. You understand? Is this what you want to do? How do you plead to both offenses? I'm going to find you guilty, follow the respective agreements. Understand that the theft case is an enhanceable offense. If you continue to pick them up, at some point, they're going to hit you with a felony offense and you'll be looking at years instead of days. Understand? Good luck, man. Yes, ma'am. Hey.
Good morning, Judge.
Hey, bud.
You got Mr. Rafael Peña.
Is it Pena?
Or
Is it hyphenated?
no, this,
Just
Pena, P-E-N-A, to be Peña.
in jail?
Yes, sir.
Okay.
He picked up an AK for armor.
Okay. Anything you want in particular?
Request to Peter Bond of the, he went. You split the rabbit with the other.
I did. I'll do you what? I'll do you solid. I won't revoke the first one. I'll leave it as is.
And the new bond will be set at?
No, there's a bond set.
Oh, the bond set?
Yeah, it's set at 1,500. I'll leave the old cases.
Yes, sir.
Hi. Ready? Please.
On Mr. Mobley.
Yeah.
And Mobley is probably.
We did it to right with the last setting, and it looks like it's recommending the no, basically, needed for a change in SOP.
The problem is he didn't do anything with,
But I think it's because he has the meeting, possession of marijuana addict, they didn't want to push him on water.
oh, right,
This is the one that that we restored.
I remember.
In an attempt to allow him, we're asking for anything to put back on his appraisal. He's the one that told that he had an aspiration to join the army or the Navy. I apologize. That's how we recruited him for when he gets so ready today. Not the recruiter, but the
Roger, do me a favor. Will you ask them to bring him out?
He's here. He posted.
Oh, he bonded out. Is mom here?
No, just a bond drawn. He came on the bus this morning. He has been in communication with me since he's posted bond.
So the initial was WMAC, right? We do TRAS's evaluations to give us a little headway on how to deal with certain cases, because we can't possibly know, dealing with all the people that we do, all the people that we see, we have. I mean, look at this, it's nuts. The evaluation that you took recommended WIMAC, Young Men About Change. It's kind of like an inpatient facility where you will sit in the jail for about 9 months learning life skills. This is what they recommended.
So they're going to give the young adult preschool, followed by thinking for a change in SOP.
Because of your open case, we can't do it. So what I'm going to do though, is if we have an alternate path for you now, do you want to describe it if you don't mind, Tori?
So the young adult preschool will be reported twice a week. The county vet, probation officer, will work with the resource center, transportation teams, and board of one. I'm gonna make sure you get bus pass and all that stuff. The local or also the option for it. They're gonna control all the SOPs, tap on it, so you'll report to the probation to the those diseases.
We are bending over backwards to help you, Mr. Mobley, and I'm telling you now, as a sanction, If you pick up a new case, if you violate again, we are going to do YMAC, the boot camp, in custody for a minimum of 9 months. Do you understand? So the next time you start thinking and it appears to be some kind of shenanigan, and I don't care what it is, you may find yourself that you bought a ticket to WiMAX. You and only you hold the keys to that cell. And I don't care if your mother, your grandmother, Jesus is here, is crying for you. You violate again, you know what's going to happen. Do you understand? That'll be your third strike. Okay, let's do it. We'll see how it works out. Extend it for a year. Last chance. Okay, all right, Roger.
Thank you, Your Honor.
You got it, bud.
May I be excused?
Yes, sir. Sorry. All right. Good morning, Mr. Belloc.
Good morning, sir.
Sir, you're charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement. They're offering you 6 days in jail with credit for the 25 days that you have done. You were giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you accept this agreement, it's final. You can never take it off. It will go on your record. Do you understand? Are you sure? It means you plead guilty and it goes on your record. But did you understand what I just said? Right. If you run from the cops again, do you know what happens? But you need to know what happens if you pick up another evading arrest. What happens?
Oh, I can't hear when in fact I can't hear. And I'm saying to friend, I cannot hear. Yeah, but I don't understand. I'm not couldn't hear. Couldn't hear like that.
No, it's all right. Okay, Ally, hi. Thanks for being patient.
No, that's okay, Judge. I am approaching on Destiny Ward.
Okay,
She's over in the jury box in Port 8 right now. I'm just gonna see if there's any way we might keep her out of custody today.
no, we have 3 cases. Literally, she gets it's an assault dismissed in February. Now we have 2 new cases now.
I
think
understand, Judge. So the only thing I will say is she's 17 years old right now. The state did just make contact with the CW in the terroristic threat case. The mother is okay with her coming home as long as there's no threatening, no harassing. This is kind of a crucial time for her right now. She is on track to graduate in May. However, tomorrow, Wednesday, and Thursday, she's got makeup hours that she sits in all day. And that is what is keeping her on track to graduate. So she's very concerned about going into custody. Even if we could have a delayed report-in date or something, if she could make.
show me that you, because I'm not going to take anything from. So let's do this. Roll it to tomorrow, but I want proof.
Thank you.
Show me and then we'll talk. But
Okay, thank you.
she needs to understand that. I mean, they're allegedly, according to him, being, you know, and she's on bond. It's.
I understand, Judge, and I just.
Show me tomorrow. Let's talk.
That's fine, Judge. So if I come tomorrow with proof, she can go do her hours. If she does not send me proof, she needs to be here tomorrow.
Oh, no. I'm taking her in.
Okay.
I'm taking her in right now, and I want you to show me first, and then we'll talk about a game plan on how and what we do on the outside. But I'm not taking her word for it. Not when we're on a over and over and over.
That's
She
fair,
needs to
Judge.
know that we need to.
Are you gonna be here for a few hours if I am around to try and get the proof today?
Sure.
Between her mom or someone
Yeah.
at school? Okay.
Yep.
Thank you.
Okay.
I'll work on it.
Thanks.
Judge Cockroach?
Yeah.
Your Honor, I have a plea of Sanders. On the Sanders.
Okay. Are you ready?
Can I call up?
Please.
Thank you. Mr. Shannon.
Mr. Sanders, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 6 days in jail with credit for the 2 days that you've done. You give up a lot of rights by entering into this agreement. This will reflect as a conviction on your record. From now on, you'll be facing a minimum of 30 days in jail. You understand?
Yes, sir.
You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you accept this agreement, there's no changing.
Right.
Is this what you want to do? How do you plead to the offense, sir? Guilty or not guilty? I'm going to find you guilty. Follow the agreement. Good luck to you, sir. Please do the
Thank
clerk.
you.
Thanks. Yes, ma'am.
Step over here, Mr. Savage.
Thank you.
I just look on the next week after the first one until that thing becomes the court box.
Okay, Mr. Belloc, we're back. So what are we doing today? Is this what you want to do?
Yes, sir.
You're doing it freely.
Yes, sir. Yes, sir.
No one's forcing you to do it.
Or to,
What happens if you run from the cops again?
I'm gonna be dead. I'm not gonna know.
Well, you're not going to be
I
dead,
know, I
but
know.
something bad. I mean,
You know, and answer the charge.
what's going to happen if you,
Don't know.
right, years instead of days? Do you understand?
I won't have one.
Well, I don't. I hope. So how do you plead to this offense? Guilty or not guilty?
Yes.
All right, I'm going to find you guilty, follow the agreement, sentence you to it. Good luck to you, sir.
Thank you, sir.
Okay, thanks. You ready? You ready? Guys, we are going on the record. Do not talk or talk outside if you need to, please. Yeah, it's probably better, you guys, if you don't mind coming up here. Mr. Smith, are you with Emily
I am doing
today?
Good morning.
You're free to hang out. Come on up. It's up to you. Of
Thank you.
course.
Just before we begin, I go through the case law and my notes. I know the court's busy. I'm not gonna keep it, it's not gonna be long, but it's not gonna be short. It's gonna be about 15, 12,
That's
15
okay.
minutes.
As much time as you need.
Just giving the
Rick,
court-
just be reasonable. Don't take 45 minutes.
Absolutely, I'm just giving the court a heads up.
Yes, that's fine. And to just go kind of slow so that, Ramona, and then,
Yes.
obviously, I will give you an opportunity to,
And we gave Ramona a list of our citations that we're gonna use, so we don't have to slow down, and do everything ready for the sites.
all right, we are back on the record and cause number 2580504. A writ of habeas corpus that has been filed by Mr. Cedillo regarding Mr. Barrientos. When we last left, we had heard from Mr. Barrientos. We had heard from both counsel. We had heard from state. But Mr. Cedillo filed, I guess, a supplemental brief. And Emily had not had a chance from the state to look at it. So we did a short recess to today so that you could digest it, make any last and final arguments. I'm going to leave the floor to you, Mr. Cedillo.
Thank you, Judge.
Please.
Like I said, I don't plan to be too long, but I'm gonna do three things. I'm gonna go over the case law and the writ law. I'm gonna go over the facts that we got from the witness and the record and show how we believe we met our burden. And then I'm gonna address the state's arguments. Those three things. First, Your Honor, this case is about a complete breakdown of my client's constitutional right. It's about the denial of his right to counsel. And the state is essentially gonna tell you, from their arguments, from their brief, they're essentially going to tell you that you should overlook that breakdown, that denial of my client's rights because of the passage of time and because there's a box checked on some old plea paperwork. That's essentially what the argument is going to boil down to. So let's start with in reverse. How did we get here? At the last setting, Your Honor made the point that we wouldn't be here if just a couple of months ago, my client hadn't come back from Mexico the federal government hadn't used an old felony against him to detain him. Your Honor said, pointed out that, he never really complained about this until the situation confronted him. That's exactly right, Judge. And I wanted to allay any concerns the court had about the passage of time by citing or bringing up to the court ex parte Harrington. In that case, the Court of Criminal Appeals laid out the standard for habeas relief. They talked about what custody means, and they said someone is in custody for habeas purposes if they're suffering collateral consequences. If they're suffering collateral consequences, then habeas relief applies. The inquiry is not about how long it took to get relief. There's other defenses which the state has raised about time, which we'll get to. But for the purpose of habeas, the ex parte Harrington boils down to this rule that I'd like the court to remember. If the conviction is good enough to be causing the client injury, it's good enough for the court to challenge, and it's good enough for the court to fix. It's certainly doing my client injury. In 1986, he took that plea uncounseled, and we argue without a valid waiver. When he took that plea, a few years later, that enhanced another DWI for DWI second, and most importantly, in 2006, it was used to raise a DWI to a felony. He would not be a felon if not in part for what happened in 1986. And then, of course, not only did the state of Texas use that against him, the federal government used that 20-year-old conviction against him a few months ago when he was coming back from Mexico. As a long-term resident, he's allowed to come back and forth. And when he was coming back, his felony status, which he was a felon because of partly what happened here. Now, the state doesn't really have anything to impeach my client's memory or credibility. They pointed out a few things that he didn't remember, like leaving a fingerprint or like whether he talked to the DA, but none of those things really go to the core of his testimony about what the judge said to him and what the judge didn't say to him. And that part was unimpeached, and that's the crucial part of his testimony. Now, the only thing the state is going to point you to the record is the checkbox. But for that, Judge, I remind you about what the Supreme Court says in two very important cases about waivers of fundamental rights. In Johnson v. Zerps, the Supreme Court said courts indulge every reasonable presumption against waiver of fundamental constitutional rights. You have to be very skeptical when a fundamental right, like the right to counsel, is denied. And then in 1962, they clarified the rule in Carney v. Cochran. Waiver cannot be presumed from a silent record. I quote directly, presuming waiver of counsel from a silent record is impermissible. To sustain a claim that counsel was waived, the record must show, or there must be an allegation of evidence, that the accused was offered counsel, but intelligently and understandingly rejected the offer. That's from Carney. In this case, Judge, a simple checkbox is essentially a silent record. It's not a colloquy. It's not a transcript. It's not a written, the state doesn't have any written plea admonition saying this is what the judge said. There's certainly nothing signed by my client acknowledging the rights that he heard and that he was giving those rights up. And more importantly, the checkbox doesn't defeat my client's testimony that he had a quick discussion with the judge, and it was all about that he didn't need a lawyer, and it was all about he should take the plea. So under that, Judge, I think from the record, which includes my client's testimony, we have a clear violation. So the state made a couple of arguments about what happened after that plea that I think I want to talk about. First off, the state said that, well, there were some future pleas. There was a plea in 1989, there was a plea in 2006, but the future pleas are not retroactive constitutional waivers. If my client didn't know in 1986 what he was giving up, there's been no testimony, and he took an oath and he was subject to cross-examination. The state didn't show that he had suddenly gained some sophistication, no offense to my client, or that he went to law school and suddenly knew his rights. He didn't know his rights in 86. He didn't know them down the line. And to say that maybe some other lawyers down the line also didn't look into that prior conviction does not relieve my client of the right or show that he has some kind of waiver. Just because other folks dropped the ball doesn't mean that he suddenly knew or should have known about his right to counsel back in 86. But more importantly, Judge, I'm going to quote the Supreme Court again, because they also took up a case that essentially encapsulates the state's argument. The state's trying to tell you My client had other reasons down the line, but he kind of ratified. He pled true a few times later, so it kind of ratified that first waiver. The state in Burgett v. Texas had a case, it was exactly similar. A client went to trial without counsel, he was convicted, and then later on, he had counsel, he took a plea, and then that plea went all the way to the Supreme Court. And the Supreme Court had a situation in front of them where they could have said, like the state is urging you, they could have said, plea number 2 with counsel makes plea number 1 okay. It's a waiver, it's a ratification. That's what the state was essentially arguing without arguing that. But that's not what the Supreme Court said about that case. The Supreme Court said, to permit a conviction obtained in violation of Gideon to be used either to support guilt or enhance punishment for another offense would erode the principle of that case and allow an unconstitutional procedure to injure the defendant twice. They vacated the second plea because of the uncounseled first conviction, Judge. They did not find a waiver in that case, and Your Honor should not find or imply a waiver in this case because my client had taken other pleas years down the road. The other time argument the state is making is the defense of latches. That is a defense that's allowable to them in the state of Texas, Judge, but it's not simply a defense that happens because this is an old case. Ex parte Smith and Ex parte Perez lay out the framework for when latches apply, and you have to look at the length of the delay, you have to look at the reason for the delay, who's caused that delay in relief being requested, and the state has to show prejudice. And importantly, in those cases, Judge, time alone is not prejudice de facto. The state has to explain to the habeas court what they're missing, how they're prejudiced. They have to show material prejudice. So let's look at the factors. First of all, the length of the delay. The length of the delay and the reason for the delay kind of tie together. My client was unsophisticated. He was not aware of his rights in '86. The judge told him he didn't need a lawyer. That's probably what he believed for decades. He probably didn't know that he had this right that he could go back and challenge. When the consequences came to him and he had counsel that understood the severity of an uncounseled plea, he did challenge those rights. He challenged them. The habeas is the vehicle for him to do so. So Your Honor should not hold against him that the consequences took this long to germinate. You know, he was not aware that he was injured until those consequences came about. Secondly, the reason for the delay. This is not a case, Judge, where my client was aware he had a claim and then sat back on his rights and then said, you know what, I'm going to wait until the records go away. I'm going to wait until the witnesses don't remember. Then I'm going to jump in and request my rights. That's when you could weigh against the client like that. But my client didn't know. He didn't know that. The consequences were raised by the state. The state chose the timing of when to use the allegations against him in 2006. And the federal government, the state, chose to use the allegations against him in a few months ago. So the state was in charge of when the consequences fell on my client's head, not my client. So that shouldn't be used against him. Shouldn't be held against him. The last prong is prejudice. Now, I've got two things to say about prejudice. One is the state has to explain to you, Judge, and I urge them to, how they actually are prejudiced by the passage of time. If the state can say, well, there were plea papers, you know, we know that these were destroyed, we should have fuller plea paperwork here, then maybe Your Honor might say, okay, well, that would have helped your case. We don't know what was destroyed, we don't know if any paperwork was destroyed. My client says he remembers filling out paperwork about about paying off the fine later. Maybe that's the paperwork that was missing. So we don't even know what records are missing that would have helped the state. So I think the state is asking you to presume because records might have been destroyed, it would have helped them. But that's not what the standard is under Ex parte Smith and Ex parte Perez. But what we do know about the prejudice to the state is that they were in charge of the retention policy. We know that the state chose what records to destroy. The state chose when to destroy those records. And the state chose to bring up a case with this thin record against my client. So all the consequences about we don't have enough records, you know, we have a retention policy, that should go against the state judge and not my client, because he wasn't in charge of any of those things. Again, it's not like he asked for an expunction and then now is coming and, you know, asking for the case to be vacated somehow. That's out of his ability, Judge. Also, I'm just going to take the argument to the extreme about prejudice. if you allow the state to say, we destroyed files, and so you can't review this habeas case properly. The state said they had a 5-year retention policy. Theoretically, the state could have a 3-month retention or a 6-month retention policy, and they could always defeat habeas review if they destroyed their files quickly and say, well, it's not our fault, you didn't complain fast enough. You know, there's always going to be sort of a moving the goalpost situation. My client, and going back to Ex parte Harrington, they chose to use this case. They chose to defend this record. They wouldn't be here defending this record if they hadn't used this case with these destroyed records against my client. So that doesn't weigh against my client, it weighs against the state. So because all those factors do not weigh against my client, Judge, laches is not the defense that Your Honor should rely on. And after everything, laches is about fairness. The fairness has to be put into balance, Judge. It would not be fair to allow my client's denial of a very fundamental right, a right that under Gideon v. Wainwright in a courtroom makes all other rights possible, as the Supreme Court said. It would not be fair to deny him of that right because the state chose to lay behind the law and use an old conviction, or because of their retention policy. It's not fair. So the only last thing I want to raise, Judge, is the time argument wise. The last thing I want to talk about is finality. I think the state hasn't raised it directly, though in our last setting, they said, well, if Your Honor vacates the conviction, you don't have any records, we're probably going to have to dismiss this case. And I think the court might be concerned just with the age of the case and with overturning a very old conviction. In all the habeas cases, Judge, finality is very important. It's a very important policy goal. But if we're talking about public policy, there's another public policy that I think is just as important as finality of convictions and, finality of procedure. And that is the public policy in a court that fixes its mistakes, the public policy in a court that doesn't allow injustice to stand. Everyone who's in this courtroom knows, Judge, that you hold defendants to the consequences of their action. If you look at this case, look at this record, look at my client's testimony, and you strike this conviction down because of what happened, everybody in this court will also know that Your Honor holds the bench to those same high standards. And that's an important policy goal as well. So I'm not asking the court to do anything extraordinary, Judge. The cases I've laid out point the road for relief. We have to meet the habeas requirements. We have to show proof of injury and violation. Your Honor has to not presume waiver from a thin or a silent record. We've done all that. At the end of the day, we have a client who was injured, his rights are respected, the conviction ought to be vacated, habeas relief is eligible, and because the Constitution wasn't followed in Court 5, 1986, Your Honor can fix that problem right now, today, by granting the writ, and we urge you to do so.
Okay, off the record for a second. We're done. Are you guys waiting for anything?
Judge, council's filed some motions to withdraw, so I need to
Kobe?
know- No, Aircon guard.
Oh, well, no, Kobe, you're good. We're done.
So you're not gonna appoint on the 2
Well,
motions?
no, we'll deal with that in a second. Just go. You don't have to, we're good. Ralph, let me finish up and then I'll take you up. Okay, are you ready? Okay. I just don't want you guys have to wait for us. That's it. Okay. Back on the record.
The state's position is very simple. They have the burden in a writ, and they have to prove that the waiver of counsel was invalid. The applicant refers to it as a thin record. However, we still have a record, and the record shows that the waiver of counsel was knowingly, intelligently, and voluntarily done. And that is all the evidence we have in this case regarding a waiver of counsel until the applicant testified last week. So what is the evidence we have now that he testified? He said the judge told him to sign papers and that it would be a fine. And that was about all he could recall about what the judge said. And he couldn't recall that he signed papers. Either he did not read them or he doesn't remember if he read them. I can't recall exactly, but regardless, we will never know what those papers said that he signed. They very well could have been waiver of counsel, and he was signing he was signing the papers saying that he agrees to waive counsel. But the applicant doesn't get to hold it against the state that records are no longer available. That cannot be a way that they prove there was a constitutional violation because there is a retention policy that every other county in the state has as well. So the fact that there is a thin record doesn't get to be held against the state since it is their burden to prove that the waiver of counsel was invalid. If you overturn this conviction, the court will be agreeing that the waiver of counsel was invalid. And the evidence needed to prove that is a defendant testifying about what happened 39 years ago without any notes of what occurred and just based off his memory saying, the judge told me to sign here and so I did. That alone would mean that any defendant can come forward, and if the records have been destroyed, they can prove there was an invalid waiver just based on recalling two sentences that a judge said to them. And so that's why the state believes they have not met their burden. Also, the testimony needs to be considered in light of the fact that he only recalled things that were helpful to him. He didn't recall the DA. He didn't recall how he got the deal. In the judgment, it says that the enhancement was abandoned, and he doesn't recall how that happened. He doesn't recall the actual plea was 3 days. It was the time served plea, 3 days in jail, but he'd already served 3 days. And additionally, I understand that he's now bringing this up because he was deported. However, latches isn't about why you do or don't do something. It's as soon as you knew there was an error, why was it not brought to the attention of the court to fix the error? And the reason the 1989 case was brought up is because in 1989, he would have discovered that there was an error in 1986. Because it wasn't affecting him, I assume, is the reason he didn't bring it up or pursue it or try to fix what happened in 1986 once he learned in 1989 there was an error. That also discredits his testimony that he is now coming forward and somehow can recall some exact wording by the judge, but then can't recall anything else. There was also much of the 1989 case, he could not recall what had occurred or if he had talked to his attorney about how the 1986 case, he realizes he pled guilty and didn't know that he pled guilty and that he should have had an attorney, but he did not. The law just says that it's their burden to have clear and affirmative evidence that the waiver was not valid. So if the testimony by the defendant was clear and affirmative evidence that the waiver was not valid, then that would be a reason to overturn the case. Again, the state's position is that they have not shown their burden. They have not shown evidence that it clearly was not a valid waiver. And the latches argument is the same as I stated on Friday, 39 years, no explanation for why he couldn't have brought it sooner when he did know about it or could have known about it at the earlier stages. We are harmed in responding to the writ because we don't have any of the paperwork. We would also be harmed in retrying the case due to it being 39 years old. And for all those reasons, that's why the state asks that you deny relief in this writ.
Okay. You know, I strive to try to be fair to everybody. Let's think about this, right? The length of the delay, 39 years, reason, because it's not affecting, right? Prejudice to the state, there's nothing left. So what happens if we open, if we grant, you know? How's that fair? People waive attorneys all the time. Think about municipal court. All the time people waive attorneys and they just, yeah, let's just get it done and over, you know? And I have to imagine in 86, I can't though. I can't speculate what possibly happened. I don't know. But nevertheless, I don't think it would be fair. I'm sorry, I have to deny you, right?
Thank you, Judge.
All right. Ally,
I was able to get the email from the assistant principal.
okay,
I tried to forward myself the email, but because it's her school email, it doesn't let me forward it. I did a screen capture. I took it.
yeah, show me.
So ADOC is the makeup hours. It begins on 3:31 and it's only on Tuesdays, Wednesdays and Thursdays. So ordinarily I would ask if we could just roll us a Friday, but this Friday is Good Friday, so I believe courts are closed. Am I correct? Enough?
Yeah,
Okay.
yeah. Let me bring her out and then I'm gonna.
Okay, Jen. And then, do you want me to?
Yeah, let me thin them out and then I'm gonna bring her out and we'll have
Okay.
it
you want me
checked.
to do that?
Yeah, just hang 5 minutes. Let me finish
I'm here
real
then.
quick. Hi, Stacey. Hey,
Bond conditions for Mr. Leo Alvarado.
okay. Alvarado, come up. Does he speak English? Speaks English, right?
I couldn't hear what you said.
He speaks English?
Yes.
He was given an English interlock by the magistrate, but it was a control officer when he reported it.
Oh, wait a second. He picked up another DWI. He's on bond for DWI. He picked up another one.
Oh, well, the first job I had was 2 years ago.
Mr. Gonzalez, is that right? What's that was?
So he's not been on bond for it? Was it a 2B or something?
I don't, yeah. Yeah, exactly. I don't think he ever finalized his first case.
Is that right? Do you know?
I'm sorry, Judge. Okay, yes,
So he pleads to a DWI in 24. 6 months later picks up another DWI and now he picks up another DWI.
That's fine.
We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
On March 2nd, officer in Harris County conducted a traffic stop on a motor vehicle for speeding, going 116 miles an hour. Officer observed the defendant driver to have a strong odor of alcoholic beverage, bloodshot, glossy red eyes, and slurred speech, and the defendant admitted to drinking. SFST for refused. DSC was read, and a blood search warrant was executed. Blood was strong.
Let's see if a license to drive.
It is eligible.
Mr. Alvarado, I am now taking away your privilege to drive. You are not allowed to drive. You will get a scram on one ankle and on your other ankle, you're going to get a GPS monitor and I'm giving you a curfew of 7 p.m. to 7 a.m. I don't want you out at night. Do you understand me? And I'm going to tell you now, if you violate these conditions, I'm going to go absolutely bonkers on your bond. I just made someone's bond $650,000. Do you understand me? I've made people's bonds $14 million in here before, and I'm not going to lose sleep, and I will protect my community in every freaking instance. Do you understand? If you drive, I can have a contempt hearing, and every time you drive, you can be subjected to 180 days in jail and a $500 fine on a contempt charge. Do you understand?
Yes, sir.
And if I wanted to really be an a-hole about it, I could stack it. Do you understand?
Yes, sir.
We have wide discretion on how to protect our community, and I'm going to do it in every freaking manner. You will be coming here every Monday and every Thursday so that I know that you're not using any illegal substances as well. If you fail to make one court appearance, it's just really not going to go well for you. Do you understand me? Do not drive. In this short life we have now, I'm telling you, can you file the guardian interlock paperwork, please?
Yes.
Ms. Childs, I'm going to beg you to please admonish your client accordingly, because if there's one, really will go bananas on his mom. Serenity now. Serenity now. Hi, Jamie. Ready? Come on up. Oh, I'm sorry. Did I skip? No, okay, you're together. Good morning.
How are you?
I'm doing great. I'm losing hair, but I'm other than anything. Okay,
Your
what we got?
we are approaching regarding a bond for last name Hassan with user docket.
You say Hassan? Hassan, okay. Did you want a bond?
Yes.
What's your position?
Is that your discretion, Your Honor? We see that the charge is fraud coming out of Urbana County, Virginia. We were not able to get any details regarding the probable cause of this offense, and there was no extensive criminal history, so that's a discussion.
The mom she has 3 kids, 17 years and 14-year-old. She lives with her mom, and talking about they would make my mom, she's taking care of the mom, she is.
How's she gonna get there? Do you know?
She said that they'll be able to drive. Like,
Okay.
her husband was a driver.
Is this a to be or has it been an open case for some time or is it just to be? Do you
I
know?
don't have that information.
No. Do you mind bringing out Miss Hassan, please? I'm okay with it. It doesn't seem like it's too, so now how much? What's reasonable?
Is it true?
You guys want to duke it out or something or what?
And looking out, I know whatever it's not going for, you gotta go.
I don't, I mean, you guys, what's reasonable?
2,000.
1,500. I think he's not very happy with that. The look on your face says it all. I mean, she's old enough to know actions have consequences. We'll admonish her. Hey, do you want to talk to me while we're waiting?
No, I have something similar.
Same.
We won't.
He say no, says it's gonna be totally different.
How's jail? You need to know that actions have consequences. You are wanted out of the state of Virginia. Your lawyer's asking for me to set you a bond. We don't have to, but I reluctantly will. But you need to understand that there are serious obligations for you. You have to, within the time that you're let out, we give you 2 weeks to turn yourself in to Virginia. If you fail to do it, you're old enough to know that there are serious consequences. And here, I will revoke the bond. I'm going to set it at 0, and I will not give you another one. Do you understand? I don't have to give you a bond, and I can hold you here until Virginia comes to get you. I will allow you to go turn yourself in, but if you don't, you cannot mosey on to anywhere else. If you fail to do it, you know what's going to happen. Now, the only other thing, as Murphy's Law dictates, what can happen will happen. If you wait till the last second, that's on you. I don't care. I would probably, as soon as you get out of jail, find a way to get to Virginia. Don't come to us 2 days before you're supposed to be there. Oh, damn, I got abducted by aliens. I don't care. You understand?
Yes.
All right, we were going to set your bond at $1,500. We're going to split it between them two. Once you make the bond, at that point, make your way on up to Virginia. All right? Well, we'll have your lawyer tell you exactly what you need to. It is Virginia, right? Am I? Yeah. So she'll explain to you exactly what you need to do, but essentially just turn yourself in. Once you do that, you need to let her know about when you're going to do that so they know when to look, and the state can verify that when you're in custody, at that point, they will dismiss this fugitive case against you. Okay?
Yes.
Questions? Okay, good luck.
Thank you.
Thanks. Has she waived?
Yes, that's what I'm telling her.
Okay, got it. Okay. Okay, hi, Lindsay. You ready?
I have 2 body requests.
Sure.
First one is Vince. Last name. Girlfriend is Mary Rollins.
What do you think on bibs?
So with Bibbs, there was no extensive criminal history, so there's that. But we're thinking about, a $5,000 bond, given the nature of the identity theft and the bank fraud totaling of about, $13,000. And so this is, I can pay that amount.
I would ask 10,000.
Yeah, so that's way too low. I don't know, I guess 3,500? What about your second one?
The second one is a little less easy,
A little what?
a little less easy.
A little less easy.
So
Okay,
we
what,
can go ahead and start on the second one. That would be Royce Harris.
Harris.
Your Honor. And this is out of Jacksonville.
I have Abel listed as the attorney of record on,
Maybe two Harrises.
no,
No? Harris?
yeah. There, we only have, weird, on the computer it says Abel.
I think, I'm gonna confirm what issue judge, let me look into it.
Okay. All right, so it's,
Okay, so
so what say you on
the
Harris?
state is opposed. This is coming out of Jacksonville County, Florida. And the offenses are felony battery, strangulation, false imprisonment, and written threats to kill and do bodily harm. And you're talking about a complete and lengthy rap sheet beginning in the nineties, and it has persisted to the day. Violent offenses.
I guess we can say that bail was in trouble.
But yay on the first one.
Got it.
Okay,
Do you need her to be brought?
yeah, we need it brought out so he can be admonished.
No, let's see if they're babes.
Bibbs, please. Mr. Reyes,
Yes, Judge.
if he ever violates a condition again, I'm gonna, and I don't want no more arguments at that point, but if he ever violates condition, I don't care if he goes to Chuck E. Cheese.
Oh, I got you.
I don't, he's supposed to go to work, go home. If he's with someone who's not gonna accept that, then that's his problem. He's the one that's on probation. He's the one that's got an open felony case. He's the one that's on number 10, you know? That's, he should know better.
You gotta deal, Judge. Next time you see us, it'll just be a matter.
Come up.
Jail time, jail time. I agree. I'm through with this.
I am up to here with you. Like a little child, you push and you push and you push. What's it going to take, Mr. Garcia? A year in the county? Baloney! You don't. Over and over and over. You tell me things, yet you do the exact opposite. You are skirting extremely thin ice, and it's absolutely no tolerance going forth. And if there is one more violation, I'm going to set you for a hearing, and we will have a hearing on that motion to revoke. Do you understand me? You're looking at a year on that motion to revoke. Okay. You are one, she's out of Louisiana, right?
No, I.
Jamie,
Louisiana.
this is Miss Bibbs. Yes, you, out of Click Mines. Your lawyer's asking for me to set you a bond, and I will. But we only give you one opportunity to do the right thing, and that is you must go turn yourself into Louisiana. You know, if you fail to act, there is a big consequence here. Here, I will revoke the bond. I'm going to set it at 0, and I'm not going to give you another one. We don't have to. But your lawyers asked for one. We will reluctantly give you one. But if you fail to turn yourself in, only one thing's going to happen. Do you understand?
Yes, sir.
I don't care for excuses. I don't care if you tell me you have a flat tire, you got abducted by an alien, you went to Kansas. I don't care. Do you understand?
Yes, sir.
2 weeks from the date of your release, you must turn yourself in. Let her know when you're going to head up there. The only other thing is do not wait till the last second. The excuses don't matter. You either do it or you don't. You understand?
Yes, so.
What do we say for a bond?
3,500.
Okay, that, we're setting your bond at 3,500, okay?
Yes, sir.
All right, good luck, Ms. Bates.
Thank you, Your Honor.
Take care. Is someone here with her now?
I don't believe so, Judge. I believe you're going around today. Yes, Judge, she's going around today. But the state did make contact with the complaining witness, her mother, who is okay with her coming home so long as they have no threatening or no verbal communication. And Judge, also, I just wanted to ask you, also, if you did not take her into custody and she was allowed to do the makeup hours for school, one bond condition that you might consider is no contact with the driver of the vehicle on the new abating case.
The problem is I think that she's still gonna do whatever the hell she wants to do. She doesn't care about bond conditions. That's the problem I see, Ms. Ward, is that you are gonna do whatever the hell you wanna do. You don't care about bond conditions. You just had an assault dismissed. You're on bond for a terroristic threat. 4 days later, you pick up an evading arrest, where the allegations are that you're allegedly burglarizing motor vehicles.
State would argue that bond should stay at 10,000. We would oppose that with our bond. She takes up her new case days after the one she had a dismissed case that was dismissed in February.
Judge, while I understand this particular prosecutor's position, whenever I spoke with the other prosecutor at the beginning of court today, he had the opposite opinion where he said he was
He's too easy.
unopposed. But that he was unopposed. I'm just saying, Judge, I'm getting.
It's like
the-
my grandmother, man.
That if she were to attend school, would you be willing to roll us 1 week so that she could do the makeup hours? We can take all of this back up on Monday.
Ally, I get it, but she doesn't give a rat's behind about bond conditions. So how am I to know that she's gonna comply with what we say? How do I know? She's still gonna do what she wants to do. I tell her, okay, don't hang out with this person, and then what?
Judge, just that she would be going directly to school, directly home, that is, she is essentially under house arrest, other than getting these makeup hours done so that she can graduate in May. She's already been pre-accepted into the University of Houston downtown, Northern Arizona University. She already has scholarship opportunities lined up. This is.
Kiss all that goodbye with all the crap that you picked up. Do you really want to make something in your life? Do you think that people are going to hire you when they look at you and they see an assault, they see a terroristic threat, they see evading? You think people are going to hire you? You think that they're going to give you a scholarship? Life is hard enough as it is, living as a young Black woman in today's society. It doesn't get easier. And the last thing you need to do is rely on a man. Men suck. They're not here to help you. They're out for one thing. You need to be a strong woman on your own that you can rely. You're making your own money so that you can live. Because today, people always want to rely on someone else to get something. But look at her. She, smart, makes a crap load of money, probably drives a really nice car, nice vacations, eats like, you know, when you end up with all these convictions, you will end up penniless on the street, scraping just to work at freaking McDonald's, making $7.50 an hour. Or dead. When you break into people's cars, I mean, you know how many people we have here that get shot because they break into cars? I'm gonna drug test her 30 days from today. You will be drug tested 30 days today. And I'm putting a monitor on your ankle and you will now be under house arrest, like what she's asking for. If you go out and I don't give a rat's behind what your excuse is, I'm going to put you in jail and I'm going to make your bond with 5 zeros by the end of it. Do you understand me? You just had a theft. You picked up 2 cases within a week. Or I'm sorry, an assault. You are killing any chance that you have to become someone in this life. This life is really great, Miss Ward, if you have money. It's so fun. If you don't have money, it sucks. I'm telling you. And if I need to throw your ass in there with a high bond, I'm going to do it in a heartbeat just to get you straightened up and fly right. We will not fail you. Do you understand me?
Yes, ma'am.
So she gets drug tested 30 days, GPS monitor, no contact with either of the complaining witnesses. I need her exact school schedule because I'm not going to rely on anything what she says. I don't believe anything what she says.
I can do that.
And one,
Harassing with her mother so she can let it help.
yeah,
Thank you.
sure. But Alan, one violation,
Absolutely.
your bond is going to hit 50,000, maybe 60, maybe 10, maybe 30. But chances are your mom doesn't have the kind of money to throw 30,000 at you. Do you understand? So if you go to jail, you will probably stuck like Chuck. Okay.
They request no contact with the defendant on the invading as well.
Yeah, obviously, no contact, no hang, well, she's gonna be at home. But right, regardless, no contact. Okay,
Thank you.
all right, we'll see. Oh, Sean, you want to talk about a trial tomorrow?
Yeah, good time.
Hello, Mr. P, how are you? Happy Monday. So what's the deal, Pickle?
So I'm still set. I was approaching to see if, I believe we're having church singers tomorrow. I didn't know if
He cannot try a case.
he cannot.
Mhm.
Okay.
No, so we
That's
have
what
to
I was
reset it.
confused on how that works.
Yeah,
Right,
what's, is your guy in custody? Okay.
So we need to control
I mean, yeah, we can't do it tomorrow. I'm not coming.
Oh, Judge, come on now. Okay.
Is there no way to work it out?
There's an offer on the case, Judge, for
To just adamant?
Maybe dismissal.
Okay.
Oh, well, that, I mean, I can't control it. That's up to them, but
there's a deferred offer on here.
Got it.
Other than that, we're set to go.
okay. I guess just get the 30-day trial date.
Okay.
Yeah.
Perfect.
Okay. And that's on me. I'm not gonna tag in. Obviously. Mr. Henderson, how are you, man?
On Trent, 30-day new trial setting.
No, if they accept the PTI offer, 30 days to get it done. Because it's super old. I'm not gonna 90 days in hopes that you get it done. No. Okay, Mr. Henderson, you ready?
Yeah, Molina.
Okay,
This is, you were here last week, Thursday or Friday, I believe. Yeah, picked up a felony charge, and you revoked her bond.
yes. Okay, so I'm ready to, this is entirely way too much drama. So do you have an offer on the case? Molina is the last name, Molina. Mm.
I don't believe so, Judge. There is the felony. We need to see.
Yeah, I'm not holding it. I mean, this case is 190 days old. We need to do something with it. So,
Yeah, yeah, they picked up a new felony.
He doesn't want
Hey, but she completed the course, she need to pay $30. No, available.
oh, man. Don't. So regardless, though, we need to figure out what we're gonna do. Come up, Miss Molina.
It looks like
So-
there's never a certificate provided also.
I don't, no. Put an offer. You now, your case is 190 days old. We need to put up, or you need to go to trial. Your case is way too old and it's just way too much drama. So I'm giving you a week. On Monday from today, you either need to accept a plea bargain agreement or I'm gonna set your case for trial. And I'm telling you now, if we said it, we will go. Do you understand? Okay. See you in a week.
For a week, all right.
Yep.
All right.
Please take a seat. Brent.
Hi, Jeff.
Hey, bud.
How are you?
What's up? Happy Monday?
It feels like one.
I know, I tell you. It's like kicking the ding ding, man. Right, over. All right.
Two different people. The first one is Mr. Ruff for Lee.
I'm ready when you are. Come on up, Mr. Ruff. Sir, you were charged with evading arrest or detention. You have worked. We're really gonna do deferred? Where's Mr. Ruff been? 26011 let me see. Mr. Ruff, you're charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. Boy, these last 3 years have not been very good for you, huh? Something is going on with you. We're going to figure it out. And I'm telling you now, if and you get on this thing and think that it's going to continue like the way it has, you understand. You give up so many rights by entering into this deferred. You give up nearly every right known to man getting into it. You violate conditions and you fail to appear like you were supposed to at the last one. Guess what happens? What? You will be facing a year in jail. 365 days. Do you understand? If you fail to appear, if you fail to test, if you test positive, if you don't do your classes on time. You are giving up the right to a trial, right to compel witnesses to testify on your behalf. Confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you accept this agreement, you are signing a contract stating with us that you're going to do thinking for a change, no drugs, no alcohol. You will get your TRAS done. Is it really no breath test refusal?
What I see, Judge.
Does this have something to do with the DWI?
It doesn't, Judge, but the allegations were that he was publicly intoxicated. That was like the reason for the stop in the first place, and then he allegedly ran. So that's the evading.
Was he the passenger?
There was no car. He was on board.
You know, I wonder, of all this that you have in the last 2.5 years, how much of this is due to what you got arrested for in the first place, Mr. Ruff? Let me tell you something and let me give you a bit of perspective that if I find that you use, we have a rehab facility in the jail that if you respond well to treatment, could be around 9 to 10, maybe 12 months. If you don't respond well, it could be up to 2 years. Do you understand?
I understand, sir.
I want him tested weekly, please. You will be tested like crazy, Mr. Ruff. Do you understand? And if you fail to appear, which thinking for a change did you guys have in mind?
Usually it's just the one that's on the Texas Sports website.
So the short one then?
I think that's the longer one.
Oh, that's the longer one. Okay. How do you plead to this offense? Guilty or not guilty? I'm not going to find you guilty. I'm going to withhold that for 18 months. As part of this agreement, you will do the Thinking for a Change class, a TRAS, which is an evaluation to see what other conditions you need. If they assess other conditions, you must fulfill them. No drugs, no alcohol, mental health caseload, treatment. We do what we do because we don't want you to pick up any new case. Mr. Ruff, look at me. We do what we do because we don't want you to pick up any new cases. And for damn sure, we just don't want you to graduate to felony upstairs where it's years instead of days. That's why we do what we do. It's not out of spite. It's not out of hurt. You're now on number 5 it's time to stop. And if it's dope or it's alcohol, that's a major contributing factor, then you need to take a step back. Do you understand? And if you don't, we will do it for you. All right, I'm going to follow the agreement. No breath test refusal, no drugs, no alcohol. Hey, fill the fee.
Yes.
All right. Okay, man. Good luck.
Thank you.
Okay.
Mr. Lott, this happened on the first one, I was about.
And what's your second thing? You said yes.
Mr. Cornish. This is,
Jail or bond?
I'm sorry,
Bond?
bond, sir.
Okay.
He, we previously amended his conditions for work, back on February 17th. He works weekends as well at Bechtel Corp. They like travel to Louisiana. When I approached in February, he didn't want to change the weekends to 4 AM, but he's requesting to be.
I'm not giving, he's on probation for a DWI third. He's on his third DWI third. He's got 1, 2, 3, 4, 5, 6 DWIs, and he had an intox manslaughter. Hell no.
Understood, Judge.
No.
Thank you.
I don't want him out at night at all. No.
Understood.
Okay.
Thanks.
Yeah. Ms. Jason, you're charged with assault and bodily injury. Is this the only one that we're going on?
Yes, the criminal justice record being dismissed.
Is it just two?
Yes, so just in case.
Okay. You're pleading to the assault case, ma'am. The agreement that you have worked out is 75 days with credit for the 26 days that you have done. You were giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. Is this what you want to do?
Yes.
How do you plead to the offense of assault, ma'am? I'm going to find you guilty. I'm going to follow the agreement, sentence you to it. Good luck to you, man.
Thank you.
Okay. Wait. Okay. When she first got arrested here, like 6 years ago, she was just, I mean, it's been a down. She was, looks like you. And the downhill curve that has gone with her, it's staggering. It's like one of the memes that you would see. And I don't know what the hell happened, but I wish I had a picture from the first time that we first initially saw her. Is that the first?
First DWI from 2021.
And she came in here, she was dressed to the nine, and I don't know what the hell happened, but it's really sad.
Family or anything like that. I tried to bond her out. I would have took this that early, but she's been sick because she doesn't have family or anything like that. I'm trying to reach out to you.
I don't know what, I mean, it's really heartbreaking. It sucks because anyways, sorry.
Okay. I appreciate you, Judge. Thank you.
Just sucks. We'll just continue as
Okay,
is.
that's fine.
And then, I mean, I'm gonna send him for a TRAS
No,
today.
that's fine. They gave me this paper.
And then,
That's right.
we'll set it off, I don't know, maybe 3 weeks.
That's-
And then let's see what 2 to 3 weeks, whatever, and then we'll see what the TRAS says, but
Okay, that's very good. No, but I was gonna ask you, now that he's through with the Beaumont job, now he has another job. And his curfew is until 7 PM, which is fine, that's fine, except this one, I need it changed to 5 PM to 7 PM. He goes into work at 5 PM. Oh, he goes into work at 6 PM, so he needs an hour to get to work, so I need to change from 5:40 and leave the 7 AM alone. Is that right? You got 7 AM?
Yes.
Okay. The 7 AM in the evening is fine. I just need to change to 5 PM so he can get an hour to get to work at 6 PM.
okay.
Thank you.
Mr. Reyes, if he has any more violations,
Okay.
I'm gonna go nuts.
I'm on your side,
Okay.
good.
All right.
On your side.
Alert, Malcolm 14. Not the 14th. I wasn't here that day. Did you already see the Loretta hearing or?
No,
Because the note said he's pro se.
I guess let's do it next Monday. We'll do it the Friday next Monday.
Your Honor, he just wants to know if he can violate these orders when he goes to see his probation officer, because he has a probation officer meeting tomorrow morning. So it would violate these curfew hours. So, but figured, so I don't know.
Where is it?
Old Spanish Joe?
I mean, you got to show proof that you're actually going there to Veronica, and then we'll,
That's good.
I'm okay with it, Mr. Reyes, you know, as long as he has proof that that's where he's going. Jennifer Gonzalez's bond violations again.
Oh my God. Either an execution or. Yeah. And I moved to.
We're set for a hearing for 4/6, remember?
Is there anything that regarding some
Sorry.
for Gonzalez or the inmate dating here?
You double check.
Okay, hey, let's finish up.
Yes, Judge, page 27, right? Except for Raymond Fellows here.
2501.
I think that's it.
So I revoked the bonds on who?
Washington, Watson.
Okay, hold on. Crap. So Washington. And I told him I'd do what? 4,000? Okay.
Yes.
Okay, so Washington, and then it said Watson, right?
Yes, but on 26, because there's two Watsons.
This is a 261197. Do we have a curfew on Watson? Do you know?
I don't know.
7 to 7. GPS prior to release. Okay, so Watson, anyone else that I revoked?
Not that I know of, Judge. Did you in custody and
There's another one.
not gonna revoke?
No, not on the new one. He hasn't made bond on there, you know?
They're not gonna